As has been indicated, the only basis on which Ljube Boškoski could be convicted of the offences charged in the indictment is as a superior, pursuant to the provisions of Article 7.3 of the statute. That is what is usually described as command responsibility. A primary contention of the Boškoski defence is that Ljube Boškoski was neither de jure nor de facto a superior of the police that entered Ljuboten on 12 August 2001, nor over Johan Tarčulovski, nor over the other police at the police checkpoint, police stations, the court or in the hospital where it is alleged the offences occurred. Further, it is submitted that Ljube Boškoski had no power to punish any of these persons within the meaning of Article 7.3. A great deal of evidence was advanced in an effort to support these contentions. Despite this, for reasons detailed in the written judgment, the Chamber is satisfied that Ljube Boškoski, as Minister of Interior at the material time, had the power to control and direct the police and any other operative employees of the Ministry of the Interior, including members of the Reserve Police. This power also extended to ensuring that those police responsible for investigating possible crimes, including those who were required to act at the direction of the judiciary and to assist the public prosecutor, that is, the criminal police in the Ministry of the Interior, performed their functions efficiently and lawfully. Of course, this power to control and direct extended to the accused Johan Tarčulovski, who was then an employee of the Ministry of the Interior. Contrary to some media reports and the understanding of some people at the time, Ljube Boškoski was not at Ljuboten and directing the police operation throughout 12 August. As news of the operation spread, he was asked by the President to go there. He reached Ljuboten as the operation was drawing to a close and was able to see something of events in the village from Brać's house at the entrance to the village. He was there for over an hour. The evidence discloses that he was told that there had been a successful operation against terrorists and that some of them had been arrested. He was not told that any had been shot. He saw at a little distance the 10 men who remained of those detained at Adam Amatovsky's house in the village. They had been escorted to Brać's house from the village. They were again lying face down with their heads covered, and it is not apparent that he would have had any reason to think that they had been severely mistreated. Smoke could be seen rising from parts of the village, but that could be consistent with armed hostilities against terrorists. In short, what he could see and what he was told by police gave him no reason to believe that there may have been murder, cruel treatment, or wanton destruction. By 2 days later, however, he had received police reports that terrorists had been killed. In addition, by virtue of information from diplomatic figures, human rights and other organisations, and the media, Ljube Boškoski quickly knew of serious allegations about the conduct of police in Ljuboten and elsewhere on 12 August and the following day. As this information available to him grew, it was sufficient to put him on notice of the likelihood that crimes may have been committed by the police. As their superior, Ljube Boškoski was obliged to investigate this or report it to the competent authorities in Macedonia who were responsible for investigating possible criminal conduct, so that the matter could be fully investigated and offenders punished if this was justified. For the purposes of Article 7.3 of the statute, his obligation as a superior to punish offending subordinates would be satisfied if a report was made to the appropriate authorities, which was likely to trigger an investigation into the alleged criminal conduct. In fact, 2 reports were made in the course of their ordinary duties by police of the Ministry of Interior to the appropriate authorities, that is, the investigating judicial authority and to the public prosecutor. On the evening of 12 August 2001, a report was made of the dead men in Ljuboten, and a further report was made following the death in hospital of the man mistreated in Ljuboten and then at Mirkovci police station. Ljube Boškoski was informed that the judicial authorities had been notified and that steps to investigate had already been attempted. While these reports by his officers were not full or accurate and did not detail all possible criminal conduct, they were such that they were likely to trigger an investigation. Indeed, by virtue of the existing laws, they should have caused a judicial investigation supported by the public prosecutor into each of the deaths, in the course of which the investigative judge and the public prosecutor ought also to have become officially aware of the closely related allegations of misconduct by police involving cruel treatment and wanton destruction, so as to be able to determine whether criminal charges were justified.